Hello, welcome to EPG Pathshala, course Legal Literacy. I'm one of your course teachers, Maruk Edenwala, a lawyer. In this module, we are going to look at juvenile legislation in our country. More particularly, the Juvenile Justice Care and Protection of Children Act 2000. First, let us look at the history of juvenile legislation. Juvenile legislation is an overarching law with regards to child protection in our country. It has been in existence since the 1920s, that is, before India attained independence. But in those days, every province had a different juvenile legislation. It dealt with two types: one, a youthful offender, and two, a child, that is, a destitute child. When India attained independence, several of these Children's Acts, which were prevailing in provinces, were adopted by state governments, or new Children's Acts were adopted by new Children's Acts were enacted by respective state governments. The Supreme Court in 1986 in Sheila Barse case recommended that there should be a uniform juvenile legislation in the country. The main reason for such recommendation was that the provisions of the Children Act in different states had different provisions, including regarding the definition of a child. For example, the West Bengal Children's Act, a child was a person below 18 years of age, whereas the Bombay Children's Act, a child was a boy under 16 and a girl under 18 years of age. This recommendation of the Supreme Court and the fact that India had adopted the Beijing rules, the central government enacted the Juvenile Justice Act 1986. In 2000, this act was replaced by the Juvenile Justice Care and Protection of Children Act 2000, which came into force from 1st April 2001. Certain amendments were carried out to this act in 2006. Today, the juvenile legislation prevailing in our country is the Juvenile Justice Care and Protection of Children Act 2000. It came into force from 15 January 2016. Now let us look at some of the provisions of the 2015 Act. Preamble. This is the object of juvenile legislation. Please see the important phrases and words. 1. Upon reading the preamble, it is clear that this law covers two categories of children. 1 is a child in conflict with law, and 2 is a child in need of care and protection. The purpose of this act is to cater to the development needs of the child. The concentration is not merely on the offense that the child is committed, but the circumstances of the child and what improvement can be made to the same. The approach which has to be adopted is required to be child-friendly, and what has to be kept in mind is the best interest of the child. And the ultimate goal and aim of this juvenile legislation is rehabilitation of the child. A child is a person who has not completed 18 years of age. Who is a child in conflict with law? A child in conflict with law is a child who is alleged or found to have committed an offense and who has not completed 18 years of age on the date of commission of such offense. So it's important to note that the definition of the child in conflict with law denotes that a person will be covered under juvenile legislation depending on his age on the date of commission of the offense. Hence, if he was under 18 years of age on the date of commission of the offense, he will be dealt with under juvenile legislation. Another important definition is that of child in need of care and protection. There are several categories of children who fall under the definition of child in need of care and protection. Basically, they are children who are unable to care for themselves or who have nobody else to take care of them, or whose parents are unfit to take care of the child. We will be seeing in the next modules how a child trafficked for commercial sexual exploitation is also a child in need of care and protection, or a child rescued from labor will also be treated as a child in need of care and protection. Best interest of the child. What do we understand by best interest of the child? When a decision is being taken with regards to the child should be the focus. We should consider how that decision will impact upon the child. A decision which is going to have a negative impact on the child cannot be tolerated or accepted. Child-friendly. What do we mean by child-friendly? It means any behavior, conduct, practice, process, attitude, environment or treatment that is human, considerate, in the best interest of the child. Child-friendly also means that whatever we do regarding a child, we should keep in mind age appropriateness of that child and ensure that the child is understanding what is happening. The 2015 Act has overturned a philosophy of juvenile legislation. The earlier philosophy was that whatever be the offense committed, the child will be treated in accordance with the child's circumstance and not on the basis of the severity of the offense. But this has been changed by the 2015 amendment. Now the offences committed are divided into three categories: petty offence, serious offence and heinous offence. And depending upon the type of offence committed, the child is treated. Petty offence is an offence where the punishment under the Indian Penal Code or any other law is up to 3 years. Serious offence is when the offence committed punishment under the Indian Penal Code or any other law for time being in force is between 3 to 7 years. And heinous offence are those offences where the minimum punishment for that offence under the Indian Penal Code is 7 years or more. The maximum punishment is not written under the category of heinous offence. These are certain general principles of care and protection of children. It is contained in Chapter 2, Section 3. It reiterates the principle of best interest. It also talks about the principle of safety, which means that when a child is within the juvenile justice system, all steps should be taken to keep that child safe. Also, that when the child is within the juvenile justice system, a child should be accorded positive measures. Whatever is done with regards to the child should have a positive impact upon the child. Certain other principles are continued in this slide. Now, Juvenile Justice Board. Under the Juvenile Justice Act, a separate system, that is a juvenile justice system, has been established to handle cases of children who have committed offences. Now, Juvenile Justice Board. Under the Juvenile Justice Act, a separate system, that is a juvenile justice system, has been established to handle cases of children who have committed offences. A child who has committed offences is not to be introduced into the criminal justice system. It is believed that a child is more amenable to reform and to rehabilitation, hence he should not be allowed to mingle with adult prisoners. Also, a child has committed this offence because he does not have the same amount of physical or mental maturity which an adult has. Hence, he should be given a chance to rehabilitate himself. Hence, a matter of a child in conflict with law is not dealt with by the criminal courts, but is dealt with by the Juvenile Justice Board. A Juvenile Justice Board consists of 3 members. One who is a judicial magistrate and 2 others who are social workers, and at least one of the members should be a woman. The purpose for this constitution of the Juvenile Justice Board is that it does not adopt a legal approach, it adopts a psycho-socio-legal approach. Juvenile legislation also continues to say that whatever offense a child may commit, he should be dealt with and produced before the Juvenile Justice Board. Whether it be murder, whether it be rape, whether it be theft. Every district must have a Juvenile Justice Board. Now, when a police apprehends a child, you will notice that juvenile legislation has different semantics and words. It does not use words such as arrest, remand, accused. It has very different language, which is not adversely impact upon a child and does not treat the child as a criminal and affect his dignity and worth. Hence, upon apprehension, the police are to produce the child before the Juvenile Justice Board within 24 hours. They are also required to inform the parent or guardian of the child and the probation officer or that the child has been apprehended. It is a job of the probation officer to prepare and submit a social investigation report before the Juvenile Justice Board within 15 days. It is a right of a child in conflict with law to be released on bail. Whether the offence under the criminal law is bailable or non-bailable, a child's right cannot be disrupted, so he should be released on bail as soon as possible. He may be released on bail with or without surety, or he may be released under the charge of a probation officer or a fit person. Emphasis is on release of the child. A child may not be released on bail only in 3 conditions. All these 3 conditions are those where the child would be adversely affected if he is released on bail. If a child is not released on bail, he is to be kept in the observation home. Pending inquiry, a child not released on bail is placed by the Juvenile Justice Board in the observation home. There are certain new provisions which have been introduced by in the Juvenile Justice Care and Protection of Children Act 2015. These provisions were strongly opposed by child rights activists, as it allows the Juvenile Justice Board to shift a child between 16 to 18 years of age who they believe has committed an heinous offence into the criminal justice system. Such child is to be denied inquiry before the Juvenile Justice Board and is to be tried by the Children's Court. The state government, with concurrence of the High Court, has to designate one sessions court as a children's court. Prior to shifting the child into the criminal justice system, the Juvenile Justice Board is supposed to conduct a preliminary assessment. What is the purpose of the preliminary assessment? It is to assess the child in conflict with law's mental and physical capacity to commit such offence, ability to understand the consequences of the offence, and the circumstances which resulted in him committing the offence. Ultimately, the Juvenile Justice Board has to identify whether the child can be rehabilitated within the juvenile justice system or not. Most child psychologists and psychiatrists say that a child can be rehabilitated within the juvenile justice system and there is no need to shift the child into the criminal justice system. While conducting the preliminary assessment, the Juvenile Justice Board must take the assistance of experienced psychologists or psychosocial workers or other experts. But the question being asked is, are there such experts in every district? There may be in metropolises, but what about remote districts? Will the Juvenile Justice Board be able to avail of such assistance? It is also important to note that the preliminary assessment should be conducted within 3 months from the date of first production. On completion of preliminary assessment, the Juvenile Justice Board has the choice to continue handling the case within the Juvenile Justice Board itself or to transfer the matter to the Children's Court. When the matter of a child in conflict with law who has committed an heinous offence and is above 16 years of age comes before the Children's Court, the Children's Court also may decide that the child should continue to be treated under juvenile legislation, and the Children's Court will deal with the child as a child in conflict with law. But the Children's Court may also decide to treat the child as an adult and deny him the provisions of juvenile legislation. In case the child is treated as an adult, the Children's Court can pass any order regarding the child, but it depends upon the situation and the circumstances of a particular child. But it is important to note that the Juvenile Justice Board cannot pass an order of capital punishment, nor can it imprison a child for life without an opportunity of release. A child is not to be sent to jail. The Children's Court too must send the child to a place of safety. The child remains in a place of safety till he or she attains the age of 21 years. After that, another assessment is to be conducted, and if the Children's Court feels that the child has been rehabilitated, the child may be released, and if not, the child will be shifted to jail. Hence, it is very frightening that a child who has committed an offence between the age of 16 to 18 years because of mental immaturity may still end up in jail. May still end up in jail. Okay. Section 18, subsection 1 and subsection 2 deals with orders that may be passed by the Juvenile Justice Board in case of any offence committed by a child below 16 years of age, or petty or serious offence committed by a child under 16 years of age, and can I say it again? Section 18, subsection 1 and subsection 2 apply to orders that can be passed by the Juvenile Justice Board on finding that a child between section 18, subsection 1 and subsection 2 deals with orders that may be passed by the Juvenile Justice Board. Such orders can also be passed regarding a child between 16 to 18 years of age who has committed a petty or serious offence, or a child between 16 to 18 years of age who has committed an heinous offence, but the Juvenile Justice Board has decided to entertain his case as a child in conflict with law. What are the orders which the JJB can pass? While passing such order, the JJB is required to consider the nature of the offence. Does the child require supervision or intervention? What are the circumstances that have been brought out regarding the child in the social investigation report, and the past conduct of the child? These are the different types of orders that the JJB can pass. You will notice that a child in conflict with law cannot be imprisoned under section 18 subsection 1. At the most, he can be institutionalized in a special home where he can be kept for a period not exceeding 3 years. The Act has also stated what are the services which should be provided to child in a special home. Reformative services including education, skill development, counseling, behavior modification, therapy and psychiatric support. But a JJB regarding a particular child may select to place the child in a place of safety instead of a special home if the JJB believes that it is not in the best interest of the child or other children to place him in a special home. You will notice that under section 18 subsection 1, a child cannot be placed in prison. In addition to passing orders under subsection 1, depending upon the special circumstance of the child, the Juvenile Justice Board may also pass orders under subsection 2. This is to meet the special needs of the child. It is important to note that if a child who has committed an offense is addicted to drugs and psychotropic substances, the Juvenile Justice Board may order that he should undergo a de-addiction program. It is extremely important to note that at certain times children commit offenses because of certain gaps in their development needs. So it is important that these gaps are filled by the orders of the Juvenile Justice Board. Now we are looking at the other category of children, which is children in need of care and protection. You remember we saw the definition of children in need of care and protection. The rehabilitation of such children is to be dealt with by the Child Welfare Committee. At every district, a Child Welfare Committee requires to be constituted. A Child Welfare Committee consists of 5 persons, one of whom is a chairperson, and at least one of them should be a woman. They should be involved and engaged in child-related developmental activities. Section 31, subsection 1 deals with who can produce a child before the Child Welfare Committee. Upon reading this slide, you will note that any person can produce a child before a Child Welfare Committee, but it is important for the Child Welfare Committee to ascertain whether the child is actually a child in need of care and protection or not. In fact, the child himself can produce himself before the Child Welfare Committee, but this rarely happens. This slide is extremely important because it has penalized the keeping of an abandoned, lost child or child appearing or claiming to be an orphan without family support. An organization or any other person who comes in contact with such child must produce the child within 24 hours before the Child Welfare Committee or the police or the children's home. If they do not do so, they could be punished up to 6 years or fined up to 2,000 or both. So such information must be disclosed to the prescribed authorities. There are different types of orders which the Child Welfare Committee must pass. These orders also have to concentrate on rehabilitating the child in need of care and protection, and in an attempt to ensure that the child does not return to such exploitative or abusive situation. While passing an order, the Child Welfare Committee must pay heed to the social investigation report which has been submitted by the Child Welfare Officer. Also, the wishes of the child should be considered if the child is mature enough to give his preference. No, can we? These are the different orders that the Child Welfare Committee can pass. Firstly, the Child Welfare Committee must declare that a child is a child in need of care and protection. The next, the Child Welfare Committee may restore the child to his parent or guardian or family, whether under supervision or not. If a child has to be given into adoption, then the child is to be placed in a special adoption agency. Also, a child is placed in a special adoption agency if the child is under 6 years of age and the parents of the child require to be traced. A child may be placed with a fit person, a fit institution, may be given in foster care, sponsorship. Foster care, sponsorship and aftercare are alternative treatment for the child. Okay, just let it be. 1 minute, just go ahead. Okay? Oh, no, just go ahead. No, go ahead. No means go backwards. Okay, no. Okay. Please read this slide carefully. The DCPU, that is the District Child Protection Unit, also plays an important role in implementation of the Juvenile Justice Care and Protection of Children Act 2015. Alternative care. Under this act, adoption, foster care, sponsorship and aftercare have been mentioned as alternative care. The main object of sponsorship is to keep the child within his family and to prevent the child from getting institutionalized. Hence, the state or the sponsorship program provides support to the family to ensure the child is kept with the family. Aftercare. Aftercare program is a program where a child requiring support after having crossed the age of 18 years is provided such support. Because a child up to the age of 18 years may have been in the special home or the children's home and requires special support before joining community life. Just go back.
We can just say.
Just go back. I'll just say. Section 74 to Section 85 deal with other offences against children. You may read that. It is contained in Chapter 9 of the Act. Another important thing is determination of age. How are you going to determine whether the person produced before the court is a child or an adult? Section 94 lays down the procedure for determination of age. In fact, this procedure is also extremely important when we work with the Child Labor and Adolescent Prohibition and Regulation Act or the Immoral Traffic Prevention Act, because determination of age is important in every child-related legislation. So please read Section 94 very carefully. The best proof of age is the birth certificate or a school document. In the absence of these two, which are called documentary proof of age, then the child may be sent for medical examination to determine what his age is. So we have in detail, So we have, in as much detail as we could in this limited period of 30 minutes, tried to examine the Juvenile Justice Care and Protection of Children Act 2015. But I finally want to say, as that we have social workers should take steps to ensure that no child under 18 years of age is dealt with within the criminal justice system. We should give that child the benefit of the juvenile justice system. It is also important to note that as far as possible, we should try and ensure that all children, whatever be their age, whatever be the offense they have committed, are dealt with within the juvenile justice system, because only then will the child be assured rehabilitation. Thank you.